Attending the oversight hearing of the Senate Committee on Business Professions and Economic Development and the Assembly Committee on Business and Professions. We're here today to discuss how the recent United States Supreme Court decision in North Carolina State Board of Dental Examiners versus the Federal Trade Commission affects our boards under the Department of Consumer Affairs. This is an incredibly important issue facing the department and the state. And I'm pleased to welcome the Director of the Department, Awad Kidani. Thank you for being here, Mr. Director, and your participation. Really appreciate your commitment to the department as well as to coming to some resolution on this issue as well. It's an important one. And also to welcome the members of your staff who are here as well in the Legislative Counsel's Office, and the Attorney General's Office, and the Center for Public Interest Law. Thank you for all of your participation today. As will be discussed in greater detail by our presenters, since this case involved a state regulatory board that was sued by the Federal Trade Commission for anti-competitive actions, in siding with the Federal Trade Commission, the Supreme Court established guidelines to establish state immunity for regulatory boards, that is, protecting them from lawsuits. We want to ensure that our boards are operating within this new legal climate. So I've invited the presenters today to discuss their opinions and views regarding this decision and offer recommendations to the legislature for any legislation that would be necessary to protect the state and these boards from potential antitrust litigation. So it's great to see everyone, and I want to welcome Assemblymember Jones, who is here from the Assembly Business and Professions Committee as the Vice Chair.
Thank you, Senator Hill, and your staff and the senators and assembly members that have joined us. As Vice Chair of the Assembly Business and Professions Committee, which has regulatory oversight over many of the professional licensing boards in California, this discussion is both timely and relevant, and thank you for calling it today. The outcome of the North Carolina dental case has left many unanswered questions about the desired composition and the oversight of professional licensing entities. Hopefully today's conversation will shine some light on what, if any, changes, as you mentioned, the legislature needs to consider to ensure that our professional regulatory boards are protecting consumers and not solely the interests of those who are charged with the regulation of their own profession. By the end of today's hearing, we may have a better idea of what satisfies state supervision and what is the correct number of active participants on any given board, and what the state can do to better protect its regulatory boards from anti-competitive behavior. Both the Assembly and Senate committees are invested in oversight and regulatory framework of California's professional licensing boards, and this hearing today gives us an opportunity to identify solutions to ensure optimal regulatory oversight for both the professional licensees and the boards charged with professional regulation. And so thank you again for today, and I'll look forward to a lively discussion.
Thank you, Assemblymember Jones. We're also privileged today to have other legislators present, and if you'd like to make some comments, Assemblymember Dodd.
I appreciate the opportunity to be here. I think this is something that I appreciate the chair calling this hearing, and looking forward to hearing testimony.
Very good. Thank you.
Bill Dodd, District 4 Assembly.
Thank you, Mr. Dodd. Senator Block, would you like? Welcome today.
Yeah, great to be here. Looking forward to a good discussion on this, because it may be a very serious issue for us to deal with. Interested in hearing what folks have to say. Thank you, Mr. Chair, for calling the meeting.
Thank you. Senator Wieckowski, welcome.
I'll try to limit my remarks here. I'm concerned. I appreciate all the briefing that we received. I have some questions, particularly with the guidelines that the FTC has come out with. I think that they are maybe have overstepped their bound. It's my reading of the case that this rogue dental board really went out of its way to be anti-competitive. And I'd like to make sure that the speakers come up, that we make a distinction between regulating the dentist and in regulating non-dentists. I mean, this is a board that felt that they had to go after non-dentists who were whitening teeth, and somehow that they came to a conclusion that only dentists could whiten teeth, which is absurd in my mind in 2010, 2008, 2015. But they felt so anti-competitive that they had to take that step. And then, as illustrated by Justice Kennedy's opinion, not only did they lose once with an administrative law judge, they lost twice. And then they appealed it, and then they went to the Supreme Court. And I'm sure that our director of DCA and all the members of the legislature, whether we're in the Assembly or the Senate, when we have our oversight, our overviews, or our hearings on the boards, that some of this may have trickled down. I mean, we're parsing the words that whether the supervisor is going to have veto power and things like that, but it's unbelievable to me that this would not have come out in the normal routine of our oversight, that we would say, oh my God, how over whitening teeth? Are you kidding me? And the California state legislature, the system that we have is such that it would have never gotten that far. So I'm cautious about what we need to do given this regulatory and the oversight system that we already have. I think that I look forward to working with the chair on your suggestions and the things that are raised here. I think at the very least, a continuing education course on antitrust behavior would be a good idea for all our board members that are zealously representing their profession, and that's okay. So,
and I think you made some good points, Senator Wieckowski, because the purpose of today is to kind of flush out all of those suggestions from the legislative analyst, the Village Council, the Attorney General, and the Fair Trade Commission, and some of their recommendations, and then and look at the department to see what suggestions they may have that they're looking at, and then at the end of the day, we can kind of work to develop some guidelines for the future and a way. And it's not just as much as, I don't look at it as just as easy as having an anti-competitive workshop. There has to be a process and a structure in place to prevent that any opportunity for the anti-competitive behavior on the part of the board. So that, I think, we just have to have a process in place, and that's what this dialogue will help with that. So thank you for the comments and your interest in the issue. It's great. So we'll move on to the first hearing. Joanna Varner from the Office of Legislative Counsel. Thank you, Joanna, for being here today, Ms. Varner, and looking forward to the discussion. And we all have a copy of her. It's online. The copy. It is online. Very good. Thank you. Very good. Welcome.
Hello. Good afternoon, senators and members. My name is Joanna Varner. I'm attorney with the Office of Legislative Counsel. I will be testifying about the legal landscape of state action immunity. Sorry about that. Leading up to the Supreme Court case in the North Carolina Dental Board case, and providing an overview of that case. In general, federal antitrust law generally prohibits anti-competitive conduct, such as unfair competition, monopolies, agreements and restraint of trade. However, the federal law itself does not provide an exemption for states. That is a judicially created exemption. The first came about in 1943 in the United States Supreme Court case Parker v. Brown. In that case, the court held that state actions are immune from antitrust liability, creating what is commonly referred to as state action immunity. However, in that case, the court cautioned that a state does not give immunity to those who violate the Sherman Act by authorizing them to violate it or by declaring that their action is unlawful. So in other words, the state can't authorize other actors to violate antitrust laws. It has to be state action in order for it to be immune. So accordingly, following Parker in 1943, the United States Supreme Court issued a series of decisions that really started to develop the application of state action immunity by examining the nature and extent of state involvement necessary in order for state action immunity to apply. So at the highest level were actions of the state acting in its sovereign capacity. So the legislature enacting legislation, the Supreme Court issuing rules. Those are automatically immune. And at the lowest level, we have actions of private parties that have been delegated some sort of function by the state. Now, for the actions of private parties to be immune under state action, there's two requirements, and these are commonly referred to as the mid-cal requirements from a Supreme Court case. The first requirement is that they have to be done pursuant to a clearly articulated state policy to displace competition. And then the second requirement, and the one that we'll all be talking about today, is they have to be actively supervised by the state. Now, the court also looked at kind of in the middle of the spectrum. For instance, it looked at municipalities such as cities and counties. In a Supreme Court case held that for municipalities, the first requirement is necessary for clear articulation, but the second requirement of active supervision is not required because the thinking is that because they are municipalities, they are public actors and they act pursuant to public, not private interest. So the Supreme Court didn't see the need for active supervision for municipalities. Now, in regards to sub-state agencies such as boards and commissions, what's important to note is prior to North Carolina, no Supreme Court case explicitly required the active supervision requirement. So the common thinking was that although the clear articulation was required for a grant of immunity, active supervision maybe wasn't. However, no case explicitly held that. There were some cases that maybe it could be implied. There were some cases that mentioned the possibility of a market participant exception. Whereas if the state is actually participating in the market they're regulating, that they would no longer be immune. However, this was never really applied. It was just kind of mentioned in dicta that it could be a possible exception. It was parsed out a little bit in the lower courts, but the Supreme Court never really applied it. So there's a bit of ambiguity there prior to North Carolina, but the bottom line is before North Carolina decision, no Supreme Court case actually specifically required active supervision for the state boards and commissions. Okay, so that leads us to the North Carolina case that was issued this past year. So the facts of that case are as follows. The North Carolina State Board of Dental Examiners is a fully fledged state agency. It was authorized to regulate the practice of dentistry by establishing a licensure system and enjoining the unlawful practice of dentistry. The board is comprised of 8 members, 6 of which are required to be licensed, actively participating dentists. And the North Carolina statutes did define the practice of dentistry. However, they did not define the practice of dentistry as including or excluding teeth whitening, and neither did the board's regulations or rules. So it wasn't really specified in the law. Despite this fact, what the dental board did in North Carolina was they didn't go through the normal regulatory process. What they did was they issued cease and desist letters on their official letterhead. And they provided these letters to non-dentist teeth whitening service providers. So people in the kiosks and malls and things like that were offering teeth whitening services, directing them to cease all activity constituting the unlawful practice of dentistry. So the result of this case basically was that the court held that the dental board was not entitled to state action immunity. That's what North Carolina was claiming because the act of sending these cease and desist letters were not actively supervised by the state. And their specific holding here, that's I think the really main part of the case, is a state board on which a controlling number of decision makers are active market participants in the occupation the boards regulates must satisfy Mid-Cal's active supervision requirement in order to invoke state action antitrust immunity. So for once, it explicitly held, okay, active supervision is required for these state boards and commissions where they are controlled by active market participants. And the justification here was that state agencies are not sovereign actors. They're non-sovereign actors, so they don't get that highest level of automatic immunity from state action immunity. And particularly because these particular boards and commissions, the state has delegated regulatory authority to actual active market participants, the need for supervision is very high. So that was the justification there. In regards to what is active supervision, the court noted that any inquiry regarding active supervision is flexible and context dependent. So it really is a fact-specific inquiry. And the goal of that inquiry is to determine whether the state's review mechanisms provide realistic assurance that a non-sovereign actor's anti-competitive conduct promotes state policy rather than private interests. Although it is flexible and context dependent, the court did point to a few requirements for state action immunity. And some of these are derived from cases that led up to North Carolina, but it really did kind of condense them all into a few requirements. One, the decision, the substance of the decision must be reviewed by a state supervisor and not merely the procedures followed to produce it. Two, the supervisor must have the power to veto or modify the decision and ensure it accords with state policy, and the mere potential for supervision is not enough. You actually have to make a decision. And then three, the state supervisor may not be an active market participant. So the dissent points out several ambiguities in the majority's decision that states will have to navigate to decide how to react to this decision. One is, what is a controlling number of decision makers? Is it a majority of those voting? Can it be something less than a majority, such as an influential voting bloc? Who is an active market participant? If you temporarily withdraw from the practice that the board is regulating but intend to return, are you an active market participant? If you practice in a part of the market that you're not specifically regulating, are you an active market participant? And so the dissent said that, the answers to these questions are not obvious, but the states must predict the answers in order to make informed decisions about how to constitute their agencies. So to sum up, the North Carolina case really is a landmark decision because it explicitly required for the first time that the anti-competitive actions of state boards and commissions controlled by active market participants be actively supervised by the state in order for state action immunity to apply. So thank you for your time.
Very good. Thank you very much. Any questions? Yes, Senator Wieckowski.
So North Carolina says that this is a fully fledged state board, yet they took an action for cease and desist rather than acting for regulatory relief or asking a question. Can you comment on that? Why that was like a rogue activity for a state board to take on right out of the bat to go with cease and desist?
So I'm not specifically that much aware of the specifics of the North Carolina law and how that relates, but the court did focus on the fact that these cease and desist letters, unlike the regulatory actions, were not supervised at all by the state, and so that's why it did find a lack of active supervision.
My next question is I know that the decision talks about not merely procedural, but can you highlight some of the, you act like a duck, you walk like a duck. There's in California, we have noticed hearings, we have agendas, we have nothing, everything is out in the full public, even if it's a board. There's procedures that we require here that are different from North Carolina, that may not be as transparent. And those decisions that we already have in place are part, at least I would argue, are part of our active supervision because we have it out in the public. We want everybody to know what's going on. Can you comment on that distinction of purely substance? Because I think we may focus too much.
So for the procedural aspect, the part I quoted there, that came from a Supreme Court case before North Carolina where I believe, and I can get back to you on this, but I believe what happened there was they just made sure, for instance, that a public hearing happened, that there was a particular comment period, that all of those things were followed. But they didn't actually review what happened in that comment period or anything like that. So it was just to make sure that steps were followed, not necessarily that it was the right decision and that the substance of that decision was correct.
And my final question, Mr. Chair, is can you clarify for some of the members of this committee might not be attorneys. So when not that Justice Alito and Thomas and Scalia are chaos merchants, but tell us about, just because they raise points in the dissent, what is the legal implication of that versus the decision? We've spent, a lot of the comments have been, they're being spoon-fed by Justice Alito, and what does, everything that's contained in that dissent, what is the legal effect of that?
That's an important distinction. So the dissent is not controlling. The dissent, the majority is the controlling holding here. So anything that actually will be followed by courts in the future will come from the majority decision. The dissent is not controlling.
For those non-attorneys, that's pretty clear, pretty obvious, what the dissenting opinion is. Just that, though. Thank you for the clarification, though. Senator Block.
Quick question in terms of how this might apply to California or other boards. Is it your opinion if instead of 6 of the 8 being practicing dentists, if 4 of the 8 were practicing dentists, would this have been decided differently, do you think, or 3 of the 8?
It was a little bit outside of the context of the opinion, but the opinion itself was actually limited to a clear controlling majority. So it's not clear from the text of the opinion itself if that would be the case.
So this wouldn't apply but for there being a controlling majority?
In this case, I'm not sure. I can only speak of what actually happened in the facts of the case. Okay. I know the dissent's not controlling, but to point to the dissent, it does use the word controlling as opposed to a majority. So that you could make the argument that because it says controlling, for instance, if it is an influential voting bloc or a member with veto power, you could be controlling the decision. So it is important that the case itself uses the word controlling as opposed to majority.
Okay, thank you.
And, just to kind of reference Senator Wieckowski's comments, and if I heard him correctly, he was implying that since in California we have hearings, we have a public disclosure, we have an opportunity for a lot of conversation over a decision that a board would make. And I don't know if you're implying that that would meet the standard of competitiveness.
Well, we have review of it. I mean,
Where's the review? The review comes from the oversight after the board's decision.
Correct. Which I think, even if the supervisor had veto power, she would only, or he in this case, would only have, it's after the board.
Like the director.
Right, the director, after the board has taken an action that was only focused on the competitiveness. I mean, boards may make a lot of bad decisions, right? But we do it in the open forum, and we're acting like a public agency. I think that it's the other activity, not purely. I know we focus on whether they're purely procedural, but then California, you had hearings in every January on these boards where we're able to ask questions actively about what the board is doing, what their oversights are, how their dues are being paid, or whatever we want.
But barring state, statute or state regulations somehow that apply, the ultimate decision today, well, I mean, not today because we do have some authority with the director, but the ultimate decision is with the board, regardless of what we do in the hearing, and it's the action that the board takes that is now in question based on and because that decision has not been actively supervised.
No, I agree with you. I think the question is that it would come to light with us. But we would have the opportunity to say, I'm going to introduce a bill to overturn that, or we call the board up and ask them to do it. You're correct. There may be some tweaking that we need to do on how we do our oversight with the board, or we may want to give some more deference to the director, but we have that opportunity. I don't think in North Carolina, they had nothing. I mean, once it's out the gate, I don't even know if they reviewed the decisions that the board's made.
Yeah. Okay, that's good. Very, very good. Thank you. Other questions? Very good. Thank you very much. Really appreciate the thoroughness of the discussion and the Ledge Council's information that you provided. Next, we'll move on to Robert Sumner, Deputy Attorney General, Office of the Attorney General. Mr. Sumner, welcome.
Thank you and good afternoon.
Nice to see you again.
You as well. I believe Ms. Varner did a very commendable job on going through the specific case history of the North Carolina decision as well as the law leading up to that decision, so hopefully I will not be too redundant with her remarks. In response to that, the Attorney General's office, at the request of the chair, provided an opinion on possible implications for the regulatory board schemes that are employed in California. And I believe that opinion, which was provided along with the other materials for this hearing, is fairly conclusive in its analysis of the way that the active state supervision requirement may or may not already be employed during those schemes in California. But really what I'd like to do is I'd like to make sure that in providing an overview of the opinion that was provided, that there is a tone set in those remarks. It is not the intention of the Attorney General's office that there should be any sense of crisis in response to this decision. The case in North Carolina was, as I believe Senator Wachowski pointed out, something of a perfect storm as far as finding the type of actions that could be condemned as purely anti-competitive in a regulatory market. I also want to make sure that we clear at the beginning of the discussion the fact that when we talk about anti-competitive decisions by a regulatory board, in theory, all regulation of a market by the state is anti-competitive at its nature. It's the intention to displace competition in favor of some sort of public policy interest. The requirement of a license is theoretically anti-competitive. So really, when we're discussing whether or not there is an anti-competitive action by a board, what we're really looking for is whether or not the critical factor of a state interest that has been clearly articulated and expressed is present in that decision. And that's where the prong having to do with active state supervision and whether or not it's required for any particular entity's actions is so critical. Because as Ms. Varner explained, the real question for whether or not immunity is assured from antitrust at the federal level is whether or not the action was being taken on behalf of the state. And that's why when there's no question that actions by the legislature are inherently in furtherance of a state interest, this is because it is the state itself that is clearly acting. So just at the offset, I have a discussion about what it means to ensure that these factors are being considered. Really, it's not the question of whether or not the decision was anti-competitive, but whether or not that anti-competitive market displacement decision was in furtherance of a state policy. So in light of that, the real impact, as was explained by Legislative Counsel of North Carolina Dental, is this understanding that a regulatory board, like, for example, a licensing board, is not necessarily by default considered a state actor for antitrust immunity purposes. There has to be, in addition to a policy that has been expressed by the state to displace competition, there has to be state supervision effectively to vouch for that policy and to say that, yes, even if there were market participants making this decision, they were operating on behalf of a state policy and in the state's interest. So after North Carolina, what we're really looking to do is we're looking to see a way that there is some sense of state oversight that can empower the policies put forth by the board. The other thing that I also want to point out is that, in particular to both the NC Dental decision and the FTC guidelines, there's the discussion about the presence of market participants on a regulatory board. I want to start off by saying that that might have implications that suggest a higher likelihood of purely anti-competitive motive on behalf of the board, but there is a significant state interest in having a peer review structure within a licensing board. It provides a certain element of expertise, and it also ensures that when decisions are being made on cases such as discipline, it's being upheld to a standard of professional conduct that is best recognized by market participants. So I also want to frame the idea of market participant board members as not being an inherent vice, even if there is balance with the need to safeguard against anti-competitive behavior. So turning, just to very briefly go over the opinion, what we sought to do in the opinion was to go over the potential options that the legislature and the agencies could potentially pursue. I'm reluctant to frame these as recommendations simply because actually in California we have, as was pointed out, a fairly robust system of state supervision that is arguably already in place. We are fortunate that we have a centralized Department of Consumer Affairs with an agency director that oversees the boards and programs. And really, when we talk about what could be done in response to NC Dental, these aren't necessarily corrections that have to be done, but if we wanted to provide greater confidence both in our existing structures, applicability to antitrust immunity provisions, and also just greater confidence to the board members themselves and to know that they can actively participate in the regulatory process without fear of antitrust liability. Then there are certain things that we could do in balance with our desire to have an active peer review system of regulation in California. The one thing that I would call a recommendation is something that I think we could kind of consider low-hanging fruit, which is that in light of the new NC Dental decision, there should be training and orientation for members that recognizes the potential implications of anti-competitive conduct, and also the fact that in order to preserve the record of a decision that was not based purely on anti-competitive behavior, there should be note-keeping, record preservation in order to clearly show and demonstrate the fact that the decision was rooted in a state interest and a state policy. That's actually already happening underway. The Attorney General's office has been working with both the Governor's office and the Department of Consumer Affairs to work on this training for new members, and this is something that we believe can be achieved within this year. As for other types of state supervision that could be employed, again, speaking of the fact that DCA is already a safeguard, we would look for ways that you could potentially improve the role of DCA as being a state supervisor of this type of conduct. It's helpful, at least for my purposes, to look at there as being two types of board actions that we would want to see potentially a greater amount of DCA supervision on. First of all, there's quasi-judicial, and then second of all, there's quasi-legislative. When I say quasi-judicial, really we're talking about the discipline cases. When you have a disciplinary case currently done by a professional licensing board, there are already a lot of both front-end and back-end safeguards of state actor involvement over that process. Boards typically, or really never, they don't generate the investigation. An investigation is typically brought by a complaint. It's investigated at the request of an executive officer. The Attorney General, which is yet another state actor, is involved in deciding whether or not the case should be filed. And then the board makes a decision, which is usually based on recommendations made by administrative law judges. So even if a disciplinary decision could potentially have anti-competitive implications, it was typically generated at the front end by a state actor involvement, so it really came at its inception out of a state policy interest. And there are also back-end processes of state action as well, because when the board makes the decision, these are appealable after reconsideration in Superior Court for review of those decisions as well. So in addition to there being a sense of front-end state supervision, there's also back-end state supervision, while the core of the decision is still being done in a peer review professional conduct setting.
Mr. Sumner, if I could just ask a question. You're saying that if the administrative law judge and the opinion comes down on a disciplinary case, and then it goes before the board overturns that decision, it still can go to Superior Court, so the state does have some continued action. Is that true?
In the instance that a licensee wants to appeal the action of a board in either setting, it has the right to appeal that.
Appeal that to Superior Court.
To a Superior Court, which can then go up. We see a good number of
So the board, the anti-competitiveness would not stand with the board. It would go, it could be appealed to final decision elsewhere. Good.
Right, and if it was purely based on anti-competitive behavior, it could be found clearly erroneous, and it could be overturned by a typical court.
Thank you.
And so that's the consideration for the quasi-judicial element. The other element, which I think is also discussed fairly frequently, is the quasi-legislative role of boards, which is essentially rulemaking and the promulgation of regulations. There might be more vulnerabilities in this at the front end when you consider the fact that the board initiates the rulemaking. The idea for the rulemaking can come from a number of sources, but the promulgation of the regulations is generated initially by a board decision. And when that happens, there are a number of safeguards that are simply basic accompaniment to any sort of rulemaking process in California. There's notice, there's written comment, there's public comment, reasons are articulated for promulgating the rules. I've been involved in a number of regulation processes myself, and it is a very extensive period that also at the back end includes OAL review to make sure that the various procedural safeguards for public lawmaking or rulemaking rather, have been followed. When that happens, there's also at the DCA level a certain amount of review by director. The director can typically review or veto the decisions that are made to rulemake by the boards. There are some exceptions to this in regards to examinations, qualifications, and the changes of fees. So if there were to be an option considered for enhancing the role in quasi-judicial proceedings, quasi-legislative proceedings, it might be to expand the right of the director of the Department of Consumer Affairs to review all rulemaking done by a board or program. In addition to this, I believe that under current law, the director's veto could be overridden by board action. This might also be something to be considered to ensure that the active state supervision cannot be superseded by a market participant board. But then beyond that, as far as the role of upgrading the director position, which as far as its merit, I would certainly defer largely to Director Kidani today to talk about whether or not he feels as though there are shortcomings in his level of oversight. But personally, I don't think that these directors' powers would have to be broadened to too extreme a degree, especially when you consider that really when we're talking about different decisions that would be reviewed, the vast majority of board actions are not particularly vulnerable to claims of purely anti-competitive behavior. Boards will make decisions that are fairly routine, don't have a high chance of a market impact. Boards will vote on things like newsletters. So the idea that there should be some sort of automatic approval process is not necessarily something that should be advocated. It's really, when you look at the cases like North Carolina Dental, when there is a clear market implication to what's being done by the board, that's where you would probably find worthy the consideration of greater director review. But overall, it's again, not necessarily in California that critical a situation to reform the law. Really, the legislature seeks to increase the confidence that both the state has in its boards and also the confidence of the board members to serve. These are just considerations that could be thought out through the opinion.